But first, we want to begin in Idaho, where a major motions hearing is underway in the Idaho student murders. Here's Court TV anchor Michael Ayala with a look at the death penalty in Idaho.
Murder in the first degree, maximum penalties, life in prison, or the death penalty.
Bryan Kohberger could get the death penalty if he's convicted of first-degree murder in the stabbing deaths of 4 University of Idaho students.
Do you understand the maximum penalty?
Yes.
The new law in Idaho could mean execution by firing squad if Kohberger is found guilty and sentenced to death.
We need to bring back the firing squad.
State Representative Bruce Skog co-sponsored the bill to make the firing squad a secondary method of execution in Idaho.
This firing squad is the backup method if we can't get the pentobarbital.
In recent years, pharmaceutical companies have filed lawsuits to prevent their drugs from being used in lethal injections. It's making it more difficult for states to carry out executions by lethal injection.
Pentobarbital does not have a long shelf life, so it's not as if we can stock up and hold on to it for years.
Idaho called off its scheduled execution of Gerald Pizzuto Jr. in December of 2022 after it couldn't obtain the necessary chemicals to put him to death. Pizzuto has been on death row for nearly 40 years after being convicted of murder in the deaths of an Idaho couple.
None of the firing squad executions, approximately 150 or so, in recent recorded history have been botched.
David Leroy is Idaho's former attorney general, now a defense attorney.
I think a good argument can be made that it's a humane method of execution. There is a cruelty factor, I think, of lingering between, as we have here in Idaho, 40 years and 7 years on death row, unknowing whether that sentence will be ultimately executed.
Skog says they look to Utah for direction. It's where the last firing squad execution took place.
There may be a panel of 5 or 6 persons with rifles, and one of them has a blank in it so that they're not sure who had the blank.
There is no method of execution that will always work perfectly.
Robin Marr is the executive director of the Death Penalty Information Center, which studies the death penalty.
As long as we have human beings involved in that protocol, there are going to be opportunities for mistakes. And certainly there may be problems with the firing squad.
All right, let's bring in Court TV crime and justice correspondent Matt Johnson to get us caught up on everything happening so far. Always good to see you, Matt, especially here on set. Thank you for being in here. And we know a hearing is underway. Tell us, please, what are some of the biggest takeaways at this point?
It's been a long hearing, but it's so important as we inch closer to trial. Bryan Kohberger's defense trying to get the death penalty off the table, even before his trial begins, set for summer of next year. Kohberger, accused of killing 4 University of Idaho college students 2 years ago this week. Today, his defense is arguing death by lethal injection or firing squad would be cruel and unusual punishment under the 8th and 14th Amendments of the U.S. Constitution. Take a listen.
Looking forward, we just don't have those answers yet. We don't know how that's going to unfold. I don't believe his execution is moving forward as is scheduled. And if we look at the immediate history in Idaho, and that's what I'm looking at when I'm standing before you representing Mr. Kohberger and saying to you that Idaho doesn't have a real means of executing someone. The firing squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. The history of the firing squad, which is really well written by Mr. Logston in our briefing, is that it sat on Idaho's books for years. And in 2009, it came off in light of the Bays decision. When you think about it coming off in light of the Bays decision and you look at what's happened since the Bays decision, and we're going to talk about that a little bit later today when we're talking about evolving standards of decency, we'll talk about how things have changed in this country since then. But for these purposes, when you look at that and you realize Idaho brings it back in 2023, they bring it back because it's not reliable to believe they're always going to be able to get the chemicals to execute somebody. And that's the real problem here. The firing squad hasn't been funded well enough to be built.
I think they're building it right now, as I recall, from the media at least. that the construction's actually underway, but I may be wrong about that.
That talks about understanding what a person is conscious and aware of when they face the firing squad. That's information that's important for the court when considering whether or not to strike the death penalty, because Idaho's means of execution really doesn't exist.
And the judge right now taking all of this under advisement, but kind of signaling to what his judgment might be, saying that Kohberger, if he's convicted, the execution date would be decades away from now, possibly, and we don't even know what means of execution would be available in the state of Idaho, Judge Ashley, at that particular time, if and when his execution date is scheduled.
Yeah, I mean, really good legal arguments. I don't envy the judge.
Taylor is very good.
Yes, and
fighting
the judge.
for her client.
Ooh, but having to make this decision, Matt, I know he's taking that under advisement, as you mentioned. Now, there was a win for the defense. Tell us more about that.
It's pretty much the only victory and the decision that we've seen so far today. Kohberger was asked to attend all pretrial hearings in a suit and tie instead of a jumpsuit, and you can see right there, that's video from today. He won that motion. He was arguing through his attorney, saying that the media attention, it would impact a presumption of innocence and the right to a fair trial.
I did hear information from security and from Ada County Transport regarding security measures that would need to be taken had the court allowed Mr. Kohberger to appear in civilian clothes. The state did not object to Mr. Kohberger appearing with civilian clothes. The court has employed security measures and is comfortable in terms of the security and flight risk related to Mr. Kohberger with those measures, and therefore has granted the defense motion to allow him to appear in civilian clothes.
So for all the pretrial motions, and there's still going to be a lot of them ahead, he can appear in suit and tie. These hearings are still going on, and of course this is happening there in the Ada County Courthouse. This is a change of venue, but you recognize that courtroom, Judge Ashley, very well. I spent a lot of time there because this is exactly the courthouse and the courtroom where Chad and Lori Daybell, they had their trials. That was also a change of venue there in Boise. And, you know, it's also interesting to note as they make their arguments trying to get the death penalty off the case, that didn't really work for Chad Daybell.
Yeah, what a great point and great analogy. There are a lot of good legal arguments being made, but again, we just don't know what the judge is going to do. And suit and tie, I'm not too surprised, state agreeing, but I agree with you. It's something the defense knows that they've won. Matt Johnson, thank you so much for being with us here on set. I want to welcome our guests for this hour, Circuit Deputy Solicitor April Sampson and former homicide prosecutor Melba Pearson. Thank you, ladies, for being with me today. Let's first talk about that suit and tie. Matt's excellent reporting and really the comment that this is a win for the defense, but the judge said the state didn't object. I think this day and age, pretty much any defendant that requests that, if there are no security concerns, is going to be able to be in regular clothes because they are presumed innocent. Melba, your thoughts?
Yeah, so good afternoon, Judge Ashley. Always great to be on with you. And I think that this was the correct ruling here because, number one, it is going to affect his presumption of innocence. He is presumed innocent at this juncture. The state has not presented all of their evidence. The jury has not deliberated, so he's presumed innocent. And as such, he should appear as someone who is, you know, is innocent, basically. So you put on a suit and tie, and then you're able to at least have that presentation where you feel a little better about yourself, where you're not sitting in a jail jumpsuit in orange or stripes, whatever it may be in that particular jurisdiction, and everyone's seeing you in that state and equating that with your guilt before any evidence has actually been presented. I think it's just a common decency thing, and I don't have an issue with it. If I was the prosecutor, I would agree with it as well.
Yeah, great points. I think it is common decency. Now let's turn to one of the harder arguments, April, and that is about the death penalty. And this is one of the few states where death by firing squad is an option. I know South Carolina is another one, but where do you stand on this whole argument and what the court might do with the death penalty or not?
And I think that's the problem that they're going to face, right, is we're talking about something that may or may not happen. And so I have seen, and I'm sure Melba has seen as well, where a judge will say, I am not going to rule. You have put the cart before the horse. There's no reason for us to be talking about this since we don't have a death sentence yet. So I think it is hard for a judge to make that decision. This judge can listen to all the arguments and say, well, you know what, I'm going to wait to see if we get to that point. Thanks for all of your hard work, but I'm not going to rule. I've had that happen many times where a judge does that, just so that it's all on the record, but it's moot at this point until or unless a jury determines that he needs to get death.
And I think, Melba, a presumption of innocence to already be thinking about the death penalty when theoretically you are innocent of the crimes as charged, I think that's a lot for a defendant to carry.
Absolutely. And that's why the defense is trying to take this off the table, because if you take death off the table, it doesn't mean that if he's found guilty, he's going to get no punishment. It just means he would serve the rest of his natural life in prison, likely without the possibility of parole. And so, of course, there is a lot of debate around the death penalty and whether or not, we should still be doing that. That's a discussion for another day. But the reality is that is the law in the state of Idaho, and that is the maximum. But if the judge decides to take it off the table, or if the state decides that they're not going to pursue death penalty, that is an option. But the defendant has to carry the fact that, listen, he's rolling the dice big time. This is not just, oh, I might get 20 years in prison. This is, I might die, or I might serve the rest of my life in prison. So if there's any opportunity for plea negotiations, probably not the worst thing for him to be thinking about.
Yeah, absolutely.